I'm a lawyer, and recently I was completely crushed in court by another lawyer's arguments. I was devastated by how poorly I was positioned. But later, when I started checking their sources, I discovered that they had used ChatGPT, and all the quotes and citations they submitted to the court were hallucinated. Posted by you/Illuminate. I'm an attorney practicing civil litigation. Without going too far into it, we represent a client who has been sued over a commercial licensing agreement. Opposing counsel is a collections firm, definitely not very tech-savvy, and generally they just try their best to keep their heads above water. Recently, we filed a motion to dismiss, and because of the proximity to the trial date, the court ordered shortened time for them to respond. They filed an opposition, never served it on us, and I went ahead and downloaded it from the court's website when I realized it was late. I began reading it, and it was damning cases I had never heard of with perfect quotes that absolutely destroyed the basis of our motion. I like to think I'm pretty good at legal research and writing and generally try to be familiar with relevant cases prior to filing a motion. Granted, there's a lot of case law and it can be easy to miss authority. Still, this was absurd. State Supreme Court cases, which held the exact opposite of my client's position. Multiple appellate court cases, which used entirely different standards to the one I stated in my motion. It was devastating. Then I began looking up the cited cases, just in case I could distinguish the facts, or make some colorable argument for why my motion wasn't a complete waste of the court's time. That's when I discovered they didn't exist or the case name existed, but the citation didn't or the citation existed, but the quote didn't appear in the text. I began a spreadsheet listing out the cases, the propositions / contained in the brief, and then an analysis of what was wrong. By the end of my analysis, I determined that every single case cited in the brief was inaccurate and not a single quote existed. I was half relieved and half astounded. Relieved that I didn't completely miss the mark in my pleadings, but also astounded that a colleague would file something like this with the court. It was utterly false. Nothing, not the argument, not the law, not the quotes, was accurate. Then I started looking for the telltale signs of AI. The use of M-dashes, the formatting, the random bolding and bullet points, the fact that it was unnecessarily signed under penalty of perjury. The caption page used the judge's nickname, and the information was out of order. My jurisdiction is pretty specific on how the judge's name, department, case name, hearing date, etc. are laid out on the front page. It hit me. This attorney was under a time crunch and just ran the whole thing through ChatGPT, copied and pasted it, and filed it. This attorney has been practicing almost as long as I've been alive, and my guess is that he has no idea that AI will hallucinate authority to support your position, whether it exists or not. Needless to say, my reply brief was unequivocal about my findings. I included the chart I had created and was very clear about an attorney's duty of candor to the court. The hearing is next Tuesday, and I can't wait to see what the judge does with this. It's going to be a learning experience for everyone. Top relevant comments. Commenter, holy crap, good job double-checking, and that was an insane read. He absolutely did not / does not understand the limitations of an LLM. It's very easy to do because of how convincingly wrong it can be and how impressive it can be. With all new tech, you have instances where very intelligent people end up making very stupid mistakes because of a lack of basic understanding. I love reading stories like these. Thanks for sharing. Ops response. It was absurdly convincing. The first several pages had me dead to rights. It fell apart when after the prayer for relief, he did the swear under penalty of perjury language that obviously didn't belong. Commenter 2. As a non-American, non-lawyer, could you explain to me where that language would be appropriate and what the concluding sentence of this type of document would normally be like? Ops response. An attorney is an officer of the court. We just need to sign it. The oath is built in. Commenter 3, not a lawyer either, but just to add to Ops' reply, that wording would be appropriate if it wasn't someone who's already an officer of the court, like a witness or you or me. Then the signature section should say you're signing under penalty of perjury, so as to inform the average person of the penalties for lying, which a lawyer should obviously already know. Commenter 4, I have a lawyer friend who is working with other lawyers on cases related to IP theft and AI training. She is astonished how many lawyers on her own team building lawsuits against AI companies do not know that LLMs hallucinate. They had never even heard of it. Meanwhile, the law school at my own university has now introduced a module called Legal Writing with AI into the required writing course. Op adds an edit to his post. He just filed a motion to be relieved as counsel. Commenter 5. He just filed a motion to be relieved as counsel. On what basis? Op's response. He says it's irreconcilable differences with his client. I have my doubts. Op adds a second edit to his post. The hearing on the motion to be relieved as counsel is set for the same day as the hearing on the motion to dismiss. He's not getting out of this one. Commenter 6. I know from your postings that you're super excited about seeing this one go down, but I'd be really hesitant to go hard on the guy at the hearing. The facts and briefs should speak for themselves. You probably don't get a whole lot for your client by really dunking on the guy at the hearing. The court should do that for you. Or in any case understands what's happening and doesn't likely need you going all scorched earth to make its decision. The other thing to consider is that this other attorney may still keep practicing. You may see him again, and while you may be within your rights to really dunk on him, he may not forget you going the extra mile to really stick it to him. Is it worth it? You probably already won. It may be, but I'm not sure. Op's response, you're absolutely right. I have no intention of dunking on him. I gave the court the information it needs to reach its conclusion. There is nothing more that can be gained from making a spectacle. My main point of interest is seeing how the court handles this. Op adds a third edit to his post. I have to admit, I came away from the hearing a bit deflated. The motion was not successful, and the trial will continue as scheduled. The opposing counsel who signed the brief did not appear at the hearing. Instead, he sent an associate attorney who knew almost nothing about the matter, other than repeatedly saying, "We're investigating the issue." The court made it very clear that the statements in question were misleading and false representations of the law. The judge also noted that even the court's own research attorneys didn't catch the bogus citations until they read my reply. The motion to be relieved as counsel was withdrawn. However, the court did issue an order to show cause, hearing in October to determine whether the attorney should be reported to the state bar for misconduct, specifically, for misleading a judicial officer by an artifice or false statement of fact or law, or for offering evidence the lawyer knows to be false. This falls under Business and Professions Code Section 6068, Subdivision D, and California Rule of Professional Conduct 3.3A1A3. The OC hearing is set to take place after the trial, so it won't impact the case itself. I had hoped to have more updates for everyone who's been following, but it looks like we'll have to wait until October. If you're still following along, we won the case on the merits. The same associate from the hearing handled the trial himself and failed miserably. The OC hearing for his boss is still scheduled for October. The court even told the associate to review the latest case on AI malpractice, Nolan v. Land of the Free LP, before that hearing. Update. 1 month and 2 weeks later, I can't believe it's already been over a month since my original post, which you can find here. The court held the OSC, and the attorney appeared in person, clearly remorseful. He was older, had been practicing for 35+ years, and admitted that a former junior associate had prepared the brief. He signed it without reviewing it, and only realized the issue when another attorney went to argue the motion. The court was torn. There was poor supervision and misleading citations, yet he was remorseful, had no prior discipline, and had already fired the associate. Ultimately, the court fined him $750, below the reporting threshold, ordered apology letters to both us and his client, and required proof of service filings. While the sanction could have been worse, the court cited Nolan v. Land of the Free LP. It fit the situation. We later won the case on the merits, so we weren't harmed by the brief. In the end, it was a fair outcome and a lesson learned. Always check your citations. Top comments. Commenter 1. What's the chance he lied about the junior attorney? Op. Doubtful. He seemed genuinely remorseful and probably didn't even know what AI was. Commenter 2. What happened to the junior attorney? Op. No idea. The court likely thought losing his job was punishment enough. Commenter 3. The real danger is laziness. Fake cases can slip through, hurting trust in real ones. Some older lawyers don't get AI, and some younger ones trust it too much. The legal system needs to catch up. Once people stop verifying the law themselves, it's a slippery slope toward idiocracy.